Welcome, everyone. Thanks for joining us this morning. And thanks to Binh Tuong for joining us from the Office of Lawyers Professional Responsibility to chat about Zoom and ethics related to our new working from home and remote work. Thanks for joining us. I wonder if you might just tell us a little bit about yourself, Bing. I'm not sure I got your title correct, even on the posting for this event. Why don't you tell us a little bit about who you are and what your role is with the office? Oh, you're muted.
Mute myself. There you Hi, everybody. My name is Binh Tuong. I'm an attorney with the Office of Lawyers Professional Responsibility. And, my title right now is the Interim Managing Attorney, which means that right now I've just transitioned into a role where I am managing other lawyers in the office. And with the intention that, in a little bit, I would be a full manager of lawyers in the office. But generally, what we do at the OLPR, the lawyers here, is we enforce the rules of professional conduct. So part of that, of course, is not only investigating and litigating and all that stuff that I think most people know about, but a part of that too is education. We do advisory opinions. We are on committees. And we help with, for example, I'm on the rules committee of the MSBA, so we deal with whatever rule changes that need to happen with the rules of professional conduct. We teach CLEs. We do all sorts of things, but people tend to know us from our enforcement role as people who investigate, litigate violations of the rules of professional conduct. Just a little background for myself. I've been with the office for about 6 years now. My previous job, I was an assistant attorney general at the attorney general's office, where I enforced nonprofit charities regulation and consumer fraud regulation. And then before that, I was in private practice. So a little bit of kind of a broad range of things.
And I wonder if you'd be willing to give like a quick rundown of if somebody gets a complaint against them, how that process works.
Sure. So how we're in the most part, in terms of how we get cases is through complaints. And a majority of the complaints, I'm sure people aren't surprised, is from clients. Majority is client complaints. We'll sometimes get complaints from opposing parties, complaints from attorneys, because there's an obligation under the rule that if an attorney knows of a violation of the rules of professional conduct that reflect on the attorney, you have to file a complaint with our office. So we'll get it from attorneys, we'll get it from judges. And so that's how the process starts. We look at it and we see whether or not, based on the allegations in the complaint, there's a reasonable basis that a violation of our rules occurred. And if so, then we will notice it out for investigation. And majority of our cases are noticed out to the district ethics committees, the various committees that do, and they're volunteers that do the initial investigation. More complicated cases that we know would be public, cases that are very complex, we'll do that in-house. So some cases we keep in-house, some cases we send out. And I would say about 50% of the cases we can summarily dismiss. So we look to see whether or not there's anything that would result in a rule violation or give us a reasonable basis that there's a rule violation. If so, yes, we'll notice it out. If not, we'll dismiss it. And so some of the examples of things that are dismissed is we wouldn't deal with fee disputes, for example. If it's something that looks really pretty clear to be like malpractice but not a competence issue, we'll dismiss it. A lot of times we'll get criminal defendant complainants about their public defender, for example, and it's still pending. Those get dismissed. So there's going to be a lot. And sometimes, when I first started the OLPR, I was always surprised by the complaint where, someone writes in and says, that the attorney from the other side used their legal tactics to get me to lose in court, which makes me kind of laugh because I'm like, you mean do their job, So sometimes people don't understand what it is that is, a violation of our ethical rules. They're mean to me, that kind of thing. So that's how it gets started. Then we investigate, and then we see whether or not there's a rule violation, and it can end up in a number of things. It can be dismissed after investigation. You can have private discipline, and it ranges from private discipline all the way to disbarment. So that's the range.
So I wonder, so we promised to chat a little bit about sort of our new work environment here. You know, I think, you know, we've always been able to work remotely. We've been mobile for a long time. Attorneys have, you know, had the challenge of securing their laptops and maintaining their ethical obligations even before COVID. Are there elements about what's going on right now that are unique? I mean, you know, what's unique about you know, our stay-at-home orders and the pandemic crisis that are bringing up new issues?
Yeah, I love the title of your when it came in and it said business as usual. One of
Yeah.
the things that one of the things that I saw in terms of a theme is that people are saying, hey, everyone's acting like it's business as usual. This is not business as usual. I mean, we are facing a lot of really difficult times for people, high stress, having to figure out how to work from home, but not just work from home, but work from home with a house full of kids, for example. You know, working from home with other people in the house because they are also sheltering in home. So a lot of people are saying it's not business as usual, but where it's business as usual, and if you leave this CLE in terms of an ethics question with anything, it's that our rules of professional conduct still apply, even though we are all going through something that's very unique. We, like I mentioned earlier, we have an advisory opinion service, and sometimes people call in, and that seems to be, you know, the most common question is things that people normally know they need to do because that's before COVID, they'll ask if they needs to still do it. Do I still need to do this? I'm having a hard time because I can't communicate. I'm not in my office anymore. So what phone number do I give out? Do I give out my cell number? Some lawyers don't like to do that. What about my technology? There's a lot of people are asking questions because they think because what we're going through, that the rules don't apply to them. And we have to remind people they still apply. We get that it's tough, but what you have to do is you have to comply with the rules, be creative, communicate even more, because now you have a client who is also dealing with difficult situations. So there are a lot of things as we're noticing in just the kind of questions we get, things that come up, things that we deal with. I remember, it's kind of funny when you say lawyers have already done a lot of this remote work. I
Yeah.
remember when COVID was about to happen, and everyone's like, "Oh, I'm going to work from home," and I looked at my schedule and I said, my job is just not conducive to working from home. I have 2 Supreme Court oral arguments. I have, depositions I need to defend. I have a trial coming up. I have to investigate people where I have to gauge their credibility. I have to do that face to face. There's no way I can work from home is really what I kind of threw up my hand and I said, that's it. But as we started to go through the process where the Supreme Court came out and said, you know what, all those people who are on schedule, we'll give you options. Do you want to waive oral argument? Do you want to, peer? If so, we'll figure it out. So all of a sudden, the orders come out. The courts were given some discretion as to how they wanted to do, what cases need to go forward, what cases can wait. Trying to gauge that so you can slowly get used to working Zoom, for example, how to do a hearing, just kind of ironing out those questions, giving people that time. But those were real questions that were coming out in terms of just the logistics of, what cases have to happen. What can wait? In our office, we have proceedings called reinstatement proceedings where attorneys want to get their license back. And they don't want to wait until all this is over in order to have their proceeding to get their license back. They want to go ahead. So there are going to be some cases that you can't even wait. So those are some of the tough questions in the beginning that we have to ask. And then, if we go forward with our proceedings, what do they look like?
the communication piece is, I think, super interesting. I think in my position here, a lot of assumptions are built in about how attorneys might be working, and we sort of forget about those things. But some of the challenges that our members might be having, we talk about the duty of tech competence, for example, and do you know your security and things like that. I'm wondering, what you think that the Bar Association even might be doing better to educate its members. I guess it's just really interesting to hear that you're getting calls about those. About do I still have a duty to communicate? And I've seen a lot of out of office messages saying, we're working remotely. I'll get back to you as soon as I can, but expect a delay, which was surprising to me because of the assumptions that I have about how attorneys might be working remotely. So maybe that's two questions. What other elements should we be thinking about helping our members with? And does that kind of disclaimer in an email saying expect a delay, does that pass muster?
Well, that's the thing, is that everyone practices differently, right? So we have attorneys who are always on call. So this is nothing to them. They're like, yeah, my clients always have my number. I use my phone. There's no problems, right? And then you have attorneys who they have a full staff, and their staff pick up the phone and send them a message, or they do things by mail. Or they don't use their email. There are some attorneys that don't even have a computer. Their staff does all that, right? And so everyone's working from home. So then they're thinking, okay, what do I do now in terms of communication? And I think part of communication and and it's all interconnected, because I think you mentioned earlier about technology, and one question that comes up is the failure to really get your technology together, to understand it and to be able to use it, is that a competence issue? Is it that you're not prepared, you're not thorough, you don't have the knowledge, that requisite knowledge to represent your client? So there's that element, and then there's the question of, if you don't have those things in place, how are you going to? And a lot of this is reasonableness too. Like so your practice has changed tremendously. How you communicate with your client, how are you going to address that? And so much of that is depending on your client, dependent on the issue that you're representing your client on, depending on what would actually work for you. So it becomes a case by case type of a situation, but you have to think about it. You can't just say, well, I'm working from home, and all that mail that, let's say your client sends you mail because they don't have any other technology, and it's sitting there. If your client starts to complain to our office and says, I wrote my attorney a gazillion times, didn't hear anything, I think your response of, well, I never got the mail, a couple of months later, is not going to fly, right? So I think that's the idea, is that you still have these obligations. They're going to look different depending on your situation. How do you work around that? And some of it is going to require some thinking, some creativity, working with staff. How do you normally work with staff? You still have this obligation to supervise under the rules, and so some attorneys that rely on their staff a lot and aren't supervising them because now they're working from home. What does that look like? And then confidentiality issues too. Confidentiality is like who is getting that information, and how is it being revealed? That kind of thing. So there are all these issues that we have on a day-to-day basis that are ethical obligations. They're kind of heightened because we're just looking at them from a different lens. And we have to recall that these obligations exist. One thing I remember when all this started happening is everyone started posting on social media the work from home situation. And I always got so nervous because I'm like, can I zoom into your computer or your desk and see what the file says? Because there may be a confidentiality issue right there, that you're revealing to the world potentially what you're working on, right? So I think people think it's harmless, but for me, that was just kind of like, oh, okay, these are things that I think about because this is my job. But I start to worry about if people are getting a little lax on that. Another situation was I was taking a walk and I heard somebody, I passed a neighbor and they were on the phone on a call, and I was just like, I hope, they're, whatever that call is, it's not a confidential call that anyone can hear and listen to. And a lot of people will think, oh my God, that's extreme in terms of paranoia, but sometimes it's things like that where people find themselves in a bind because they're just not thinking through some of the obligations, because they're usually in the office, they're pretty safe, but what if you're at home? Who's at home listening to the conversation? Those types of things. So all things to think about as we work from home.
And you brought up the screen sharing, and I will say that screen sharing has been one thing that I've found vital to being able to work with my clients now. So I do criminal defense, and of course, when my clients would normally want to sit down in the office and go through and watch the squad cam or watch the body cam and see what happened and how it went from the officer's perspective, and maybe go through things like that, and even to some extent going through the police reports. Occasionally there's confidential information that I'm not allowed to make a copy and send that to my client, and I have to keep that copy with me. Then the concerns are, okay, I have one copy. I'm not allowed to make copies of this. There's a non-disclosure, or there's a confidentiality order from the court. I need to share this with my client. I need to go through this with my client. My only way to do this is screen sharing. But I don't know if my client is going to have some type of recording software in the back, take a screenshot. Always things that I need to be aware of and think about. Any thoughts on aspects like that with screen sharing? I know that Mike is generally fantastic, but just moments ago, we saw him drop down and we saw the desktop and then he popped it back up. I mean, things like that, where you can see that background. Any thoughts or ideas regarding those?
It is tough because, like I mentioned, you do have these obligations. What you're doing in your day-to-day job is just changed, in terms of, for example, that what the example you make in terms of, you do have an obligation to communicate with your client, right? And so that is part of the communication. Here's what I have, and I need to share this information with you because this is part of your case. But then you have to balance that with what are your limitations. You have to follow court orders, for example. So we've always had rules that sometimes will conflict that you have to iron through, and that's why people call our advisory opinion. But this is a new way that the rules are kind of conflicting, and so there's a lot of problem solving that has to happen. Like what has to work. I think with something like that, and we do this at the OLPR too. We sit there and we think through, like, what are all the angles, right? And then we sometimes people will call our office and say, this is what I'm thinking. What do you see anything else wrong with this? And that's fair. But I think the first step is to do what you just did, which is think it through and know and kind of issue spot it. And find a way to balance all those competing interests. And a lot of it is, like I said, is going to be a case by case type situation. But yeah, when we think through our rules and the obligations there, you're spot on in terms of, yeah, I do need to communicate this. That's the first step, right? I have limitations. One of the things early on that we had a lot of questions come up is accessibility. My client doesn't have access. I have to do a remote hearing. I have to do everything electronically. What are my obligations in terms of my client's technological access to things that will allow me to communicate? And the rules don't require you to get your client a phone or get your client a computer so they can show up at a Zoom hearing. We sometimes would get questions about if your client has special needs, interpreters, or if they have difficulty hearing, how do you get them involved? And the rules are not, they don't tell you how to do those specific things, right? So there's no obligation there, but then the second question is, what can I do? What's my obligation from there? can I withdraw from representation? Sometimes we started, when things started opening up, we got questions about, the court's calling me in. They had discretion as to whether or not to hold off in cases. They're calling me in. I don't feel comfortable going to court. Do I have to? I feel that my health is at stake, but the judge is calling me in. Those are tough questions. I've not had to think through that specific one, but those are example of really tough questions that come up. And my response to that is that usually we're all kind of going through a tough time. So it would be helpful, usually if you let the court know, you could probably they'll probably be helpful in terms of being able to say, okay, here's what I'm willing to do. But you might have to withdraw if you can't fully represent your client. And so then you have to look at the withdrawal obligations. You have to act in the best interest of the client. You can't just drop the client and have them left at a trial, without representation. You have to do certain things to protect their interests, ask for continuance, those types of things to work around it. But that's the thing. That's the challenge, is that the rules are still applicable in these tough times, but you just have to find a way to kind of balance that.
There are issues that, like your clients, for example, where you don't know necessarily, or it's not a world of expertise. Are they in the at-risk population? It may not even be something, I don't necessarily know if my client has diabetes. I can see, or asthma, or what are my ethical obligations about protecting or knowing? I guess those are malpractice concerns, not ethical concerns. But we also don't want to be putting our clients at risk, just their health at risk.
Yeah, and I mean, obviously, as attorneys, you always want to do what's helpful to your client, what's in their best interest. And you may have a situation where your client's like, they may tell you, you may not know, you may not seek out that information, but they may tell you, I just don't want to appear, I don't want to show up at the deposition. And so that's one of those things, those battles that you, as attorneys, that we always have to kind of fight, right? It's just a different one with different reasons for it. But sometimes questions have come up in terms of, well, what if your client tells you they're positive? Who do you need? Do you have to tell their people? Is that a confidentiality issue then? If there's a tracing issue, if the Department of Health wants to trace who's tested positive and says, tell me. Those are the types of questions in terms of the rules of professional conduct that come into play, where for example, people have asked, what if a staff member of mine is test positive? Do I have to tell my client? And generally we'll say, yeah, you probably should, right? But then we don't answer the question related to any kind of question of law. For example, as an employer, can you do that? These are health issues. We would say, yes, you should disclose because this is information that's important to your client. But then there's the other question that you have to balance, which is the question of law. And then with the client, our thing is, if the law requires you to disclose people who, you come in contact with that are positive, that, you have to follow the law. But ideally, you'd have informed consent from the client, right? 1.6, which is the rule on confidentiality, has exceptions, and one is informed consent from the client. So again, that goes back to that communication, where this communication includes like what the process is, how COVID has changed how we do things, and just for them to know, just kind of have heads up, here's how I'm going to handle this type of situation. Does this work for you? Does this sound okay for you? So that's one of those things that before we just didn't have to think about when we talked to our clients or dealt with our clients, but now we do. So those are examples of, yes, the big picture of wanting to protect health, but it's your health that you want to protect, your employees' health, your clients' health, also whatever mandates are out there for you to reveal this information.
So not to put you on the spot here, of course, but running through a few different scenarios. So one of them is that the one that you just brought up, say you're dealing with a family law case, and of course there's child exchange going back and forth, and you're still trying to sort everything out, and your client informs you that, by the way, I just dropped my son off and got my COVID test results back. I am positive, but I don't want you to tell anybody, especially don't tell my significant other who I hate and want a divorce from. There's, as far as I know, there's no law that says if you find out somebody is positive for COVID, you must inform other people. What's the rules and what's the requirements at that point?
So the first part, yes, is there a law that requires that, right? So let's say there's nothing that says you need to. Then we have Rule 1.6, which is the rule on confidentiality, which says that you cannot disclose anything related to the representation. So, this is broad. It's very broad. It doesn't include. A lot of people think it's just attorney-client privileged information. No, it's anything related to the representation. So 1.6 says that. And then 1.6b has a bunch of exceptions to the rule. And like I said before, informed consent is one of them, impliedly authorized to carry out the representation. And there's exceptions that relate to, if there's it deals with like substantial harm or death. I don't know, I don't have the wording exactly. I can peek at my rule book.
We have it up on the screen too.
Oh, okay.
Oh, sorry.
So it is B6. It says lawyer reasonably believes the disclosure is necessary to prevent reasonably certain death or substantial bodily harm. So that's the potential question, right? Is, am I permitted, if in my reading of this rule, I reasonably believe that it's necessary to disclose to prevent reasonably certain death or substantial bodily harm. So what facts would add to that? Well, what if the family is really high risk? The wife is super high risk that she needs to know these things, right? That rule may allow you to say, you know what, I encourage you to allow me to reveal this information. Of course, that's always the first step you kind of want to do, is talk to your client and say, can I? Because I think this is important that this gets revealed. If the client still says, absolutely not, I don't want you, then you analyze as to whether the disclosure would be necessary to protect other people from bodily harm or a certain death. So it's going to depend on who's around you, and if the people who are going to be affected by this will be seriously affected by a positive test result and being exposed, and that would be, and you reasonably believe that, I have to disclose this information. There's that exception there.
And I think this is probably me, kind of taking this a step further. But of course, it's not just, my analysis wouldn't be just, is that person that the child is dropped off with likely to face certain death or substantial bodily harm, but then the people that significant other may be in contact with, maybe they're also caring for their elderly grandmother.
Sure.
Maybe they have contact with, maybe they are a grocery store worker who has contact with a lot of people out there. There's, I think COVID has put us in a situation where it's not just the next step, but there are many steps thereafter.
Sure.
I do think it's probably an analysis going along multiple steps.
Absolutely.
Another scenario for you is, and to my knowledge, the office hasn't had any direct statement in regards to that disclosure. There's nothing out there at this point. Is that correct?
Which disclosure?
Requiring or authorizing disclosure if a client informs them that they're positive. I know that there's occasionally opinions that are put out, or
No, we don't have any kind of opinion. We do, we're working on, because of these questions that come up, like a frequently asked question. that we can put up. And so some of the examples that I'm talking about are kind of things that I've seen as part of the frequently asked questions that we're working on. So you all get a sneak peek at the FAQ that will eventually be shared, but we don't have any kind of an opinion that's out there yet.
We're definitely looking forward to the FAQs. I think that's going to answer a lot of questions for people. Another scenario to throw out there and just put you on the spot, of course. We're running into situations where some of the courthouses are opening back up, but a lot of their conference rooms to meet with clients are closed. So you can't go into those conference rooms because you wouldn't have enough space to socially distance. So the courts are requiring you to communicate with your clients in the open area outside of the courtrooms. And you also need to maintain social distancing while doing that. Obviously, this is a situation where it can be very difficult to have privacy because of the number of people around. Going through the issue spotting aspect, what are some concerns you have with that social distancing, having open courtrooms, being able to have those conversations?
Yeah, early on when everyone was doing remote type hearings, that was one of the issues that came up with proceeding with a Zoom remote hearing. Was normally we're supposed to treat this like a regular live hearing, right? And normally I would be able to pass my client a note, or my client, while I'm questioning somebody, would be able to pass me a note, and that helped my representation of my client. I can't do that with Zoom. And so, and that is a fair question. I mean, because that's how, that's how people communicate. And that's one thing that was going to be taken away. And so how do you confer with your client? How do you have that interaction with your client? And we acknowledge, and I think a lot of judges acknowledge that, yes, this is different. You don't have that. The ways you communicate with your client are going to change, and we have to work around that. And Zoom, how the official solution for that is you have breakout rooms, for example. They're kind of tedious because you have to actually ask for someone to break out. And in those breakout rooms, you can actually start talking to your client. It's not the same as passing a note, but that's what we can do for you. And then people got nervous as to how secure are these breakout rooms, right? Can anyone just come in? Can anyone eavesdrop? You just kind of feel like you're on someone else's platform and you're having these private conversations with your client. So those are all really, good points and things that lawyers were concerned about. And then now that we're having these hybrid hearings where people are showing up, they're meeting with their client, but we're still keeping social distancing, those questions are getting tougher. My thing is that, people are getting creative. So I haven't done this myself, but I heard that people would, for Zoom hearings, for example, they'll text their clients, right? So that's the passing of the note. You're texting off Zoom. You're communicating, but no one needs to see it. You feel a little more secure. I don't know if that works. Like I said, this is just something I've heard people have shared with each other as techniques that they emailing each other, that kind of thing. The hearing part, the courtroom part is really interesting. And I don't know if part of that is to just try to get all those types of conversations really, as much as you can done before you show up at the courthouse, and finding ways where you can meet with your client without people around, where you can socially distance. That's really tough because you do feel that sense of, can someone hear? But I think it's going to be one of those things where you have to think through your situation and what your surroundings are, what the issues are, what's available to you. Every courtroom is going to be different. Every resource is going to be different. And if there's any way you can try to arrange for something ahead of time, if you know that you're going to have these meetings with your client, that you have to be socially distanced, that kind of thing. And my feeling is that, and I don't know in terms of what court you're working with, but if these issues are thought about, first of all, raised, and that, whoever you're dealing with will try to address it and find ways for you to work around it. Because that's at least my experience, is that people are trying to, internally with the courthouses, the court system, they're trying to figure out these types of questions. And so, if you raise it as an issue, they may be able to find some kind of accommodation for you.
And of course, one of the questions that kind of came up was sending private chats on Zoom. And I don't remember if Zoom Gov has disabled the chat function, but one of the things that at least I was made aware of early on is whoever the host is, they can get full information of everything that's being discussed and everything that's going on, even if it's a private chat between, you know, two panelists.
Yep.
If the host decides to get into that.
So one of the things, one of my tasks when we all started working from home was because at the Lpr we run a lot of, we're part of the judicial branch, but our hearings and our panel, our referee hearings, our panel hearings, we have to kind of take care of ourselves. And so that was one of my tasks, is to figure out how are we going to continue with our hearings. And I did have, had to do a lot of research on it, and that's kind of what I was seeing nationally in terms of that kind of do not use the chat function. So I think that's why sometimes you'll have a host that disables it, because they don't even want attorneys, because this is so new to so many people that mistakes happen. And that's what you don't want, is you don't want to have a situation where you're having this whole conversation with your client that everyone can see. This is not even the host having access, because the host can say, hey, you know what, I'm not going to look at it. But that even is not good enough, in the sense that it just leaves it so open for people to mistakenly DM everybody instead of just their client. So that's why just kind of helping people help themselves, a lot of times these hearings will have that disabled. The only thing you can do with the chat function is to talk to the host to say, I can't get on, my camera's not working, or whatever you need to communicate about yourself on a technology type of a question, as opposed to being able to have conversations between you and your client. That was just not recommended to allow people to do. And I think that's a good recommendation, in the sense that it just has too many risks. The benefit of being able to communicate with your client during the Zoom meeting, that passing of the note, is outweighed by the just potential of breaching confidentiality, because you just don't know how to work the system, or there's a glitch or something is wrong. So that was just something that was just not recommended for hosts to allow.
And I will say, so some thoughts that I've had just going through and having done some of these hearings is, I've done I have Google Voice for my phone, which means that I have access to their text messaging, which means I can have a separate window set up that is not connected to Zoom, where I can have that conversation with my client. I've emailed my client during hearings. I've even had the point where we've both shut off our video and shut off our mics, and I've called the client to confirm something during the middle of a hearing. It's not ideal, because of course, if the tech turns back on, there's problems, and you have to monitor that at all times. But I think there are ways, and I think the important takeaway from what you had mentioned was, don't rely on the software you're using for the meeting, unless it's maybe one of those breakout rooms that you had talked about. It sounds like the breakout rooms, you haven't seen issues with those, have you?
No, and the breakout rooms, we were told, are as part, because when I was doing this for the OLPR, I was joining a lot of the branch groups that were dealing with remote hearings, and the branch was doing it for all the counties. And that was one of the things that they said as part of their training, was that the breakout rooms, they actually work as a good option for people to meet with their client, because before anyone can interrupt, you get a warning, you get a time frame as to how long you have. So they felt that was a good way to do that. The problem with that is it's not the same as passing a note, right? You have to say, hey, it's like asking the judge for recess so you can confer with your client. So, it's a different kind of communication. It's not that quick, but that's kind of everything that we're doing, in terms of exhibits, and the whole process is a little slower and a little tougher. That's just kind of the nature of the situation we're in right now. So so part of that is just making sure your client understands, this is not the same as a live hearing in this sense. And so we have limitations. So if you do have something that you want to tell me, make sure that you don't either feel free to let me know, depending on how you want to advise your client. We can always get a breakout room, and it's kind of an extra step, but it's there. And so if you need to use it, you should use it.
And I think one of the things that, so kind of running through the questions a little bit more in order here. There was a question regarding Google Meet, but as opposed to going through each of the individual softwares, I know you did a lot of research. Were there any red flag programs out there that you see in common use that you wish weren't out there? Or are there any that you felt kind of met muster and were a little bit more secure?
No, yeah, well, we basically went with what the branch, the branch did all this. They had their own group of people who were looking into this, and they came back with, Zoom as one, because it's just one that everyone knows how to use. So it was something that the judges were comfortable with, people were comfortable with, and so when they figured out how to use Zoom, they didn't have to figure out how to use WebEx, or they didn't have to figure out some other app. So that was one of the ones that they found people used. And then the ITV, I think, is one that the courts use. They've used it for a while, so you can use that as an option. But and then WebEx, I think that's what the Supreme Court used for their oral arguments. So I don't know that there's any. I mean, I'm not an expert at all in terms of the various technologies that can be used. I think people tend to use Zoom just because it's familiarity. People just use it more, or are more familiar with it, and so that's what the courts have used. One of the things that is kind of worth noting is that, at least for us, I'm more familiar with Zoom because that's what our office uses. But like I said, the Supreme Court used WebEx, and when we did mooting for the Supreme Court arguments, we did that using the technology that we had to use before the court. That was one of the things that we thought through in terms of, you don't want any kind of technological problems. So if you're going to moot for the substantive, you might as well moot for the technology as well. And so that was something that I would recommend in terms of, if you've never used Zoom for hearing, do a run through. If you have a oral argument or a hearing before a court that has another app that you're not familiar with it, if you do any practice runs, like for example, interviewing a witness. If you're going to have a witness using Zoom, you may want to do witness prep using Zoom. Those types of things. But I'm kind of running on a tangent right now. But I don't personally know of any apps or technology that had any red flags that that were at issue in terms of my experience, but I haven't had that broad of an experience with the different kinds.
Another question was in regards to obligations. What obligation, if any, do you have if you hear what another lawyer clearly thinks would be a private communication? And you might be overhearing that based on the software.
Yeah, I mean, that's similar to any kind of inadvertent disclosures. This was back in the day when email was new, and people would just send emails to everybody and inadvertently disclose confidential information. So 1.6 has a requirement that you would take reasonable steps to make sure you don't have those inadvertent unauthorized disclosures. And I'm kind of looking up the rule right now regarding if you receive information. I think a lot of people would send it back and say, you inadvertently revealed information. I'm not going to be unfair and use it. So I think it would be the same. So like I think 4.4b talks about a lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows was inadvertently sent shall promptly notify the sender. So that's the rule that talks about the whole, you'll let people know. I think that's kind of the same idea, is that, we're dealing with different technology. We're not dealing with emails or electronic, communications, but but I think that there's part of that is kind of the same concept, which is, this 4.4 is about, requests dealing with the rights of third parties. And so that's part of it, is that you don't want to take advantage of the situation. So if you know that you have things that you shouldn't have, you may let people know and return it.
And just kind of looking at the past few months, obviously we've had several months now where people have either been under the stay-at-home order or attempting to work remotely as much as they can. Has the office seen different types of complaints coming in, different different arguments or different issues that have been coming up that we might not have been seeing in the past?
Not yet, at least for me. And I don't do my role in the office. I'm not looking at all the complaints that come in. So I usually get it when it's being investigated or have been investigated. So it may trickle, there may be a delay. But where we do see it is in questions. So our advisory opinion service is where we're seeing most of the questions about how people are adjusting or dealing with working from home or working remotely. I wouldn't be surprised though, just looking at my own practice, I wouldn't be surprised if we start getting stuff related to communication, if people are not kind of, being responsive with their clients. That's something that I sometimes I think about myself when I have a respondent who is just not cooperating. I start to wonder what's going on in their lives. What are they even getting my messages? Are they getting my emails? Where are they? So that could easily be transferred to if you are if you have a client and you just don't have the means or the capability of making sure that you communicate to them. The other thing too is something that we really need to think about is these are tough times for people who don't have any kind of mental illness or substance use or other factors that will affect their practice. So if you are a person who has those types of issues, it's going to affect your ability to practice and to respond and to do all these things that you're required to do. So I anticipate that there may be some issues related to that where as we are investigating somebody's complaint that somebody's not communicating or not diligent or whatever, that those types of issues may come out. But I think it's one of those things that on a complaint perspective, we won't see until something happens and someone complains. And so I haven't seen an uptick in that yet, but I have seen an uptick on the questions that we get as they relate to working from home.
All right. Well, just reaching out to our attendees. Any questions out there? Anything else? One of the things that we did have a anonymous question here. These sessions are good for a 0.5. So typically we do run a little bit long on these. I think we had talked about seeing if we were going to do Mike and I had talked about seeing if we were going to do a 1 hour on this. I think that, I don't know, where did we come down on that, Mike?
Yeah, we did. We did apply for a full credit on this one. Sorry, folks, I meant to mention it at the beginning of our presentation. I also forgot to mention that we were sponsored today by the criminal law section of the MSBA. So we skipped over, in our excitement to review the appellate court's website, I skipped over some of our administrative stuff. So apologies.
We the topic was just so interesting. We wanted to dive right in and get straight to it. Speaking of the criminal law section, one of the things that came up with that section, and one of the reasons that we were really interested in having these conversations, is because of those client communications and a lot of things that are going on. So when we think about our public defender members, one of the issues that we're looking at is a lot of times those public defenders don't know who their clients are before things actually start getting up and running. They don't have that opportunity to communicate with their clients before the hearings a lot of times. and it's trying to make sure that our public defenders are able to work in an ethical fashion and meet the rules and still do their job. So I think there's been a lot of concern, especially about them being able to do their job well in court. And I think we touched on that a little bit, but I don't know if there's other things that attorneys should be considering while social distancing at the courthouse. I don't know if you have any additional thoughts on that.
No, I mean, it's what's really tough is that these are all kind of, some of these scenarios are new and they're new to us. And so, when they come up, we think through them and we talk through the potential rules with whoever is calling or asking. But in terms of like this kind of general things to think of, I at this point I don't have anything, just because we haven't had enough of like any kind of pattern of questions that have come up specific to criminal attorneys, other than the concern about, I have to show up because this is an important hearing. There's no, we need to move on, and I don't feel safe. Those more personal type, balancing personal interests with client interest types of scenarios. But I know I said this before, and it's probably not helpful, but you always really have to think through the fact that these rules still apply. So you still have these obligations. It's just that it's just not the way it used to be. And so you just have to think through or think around how to make it work. And my recommendation is to talk to other people within the field, because, I don't do that on a daily basis. I work with the rules, right? So in terms of the fact specific scenarios, I don't know what people are doing to get around it or to address it or to deal with it. And so sometimes it's fellow practitioners who are like, yes, that was me. And, I raised it with the judge and this is what the judge said. And that's always really helpful, is to be able to talk to people within your practice and see what specific concerns. Each practice has their own concerns, right? So, if you are a probate attorney, for example, and they're trying to social distance and you need witnesses because all of a sudden there was an uptick in people who wanted to write their wills, right? And so you're like, how do I do it if I need witnesses? What do I do if I need, a notary, that kind of thing? If someone witnessed it through a screen door, is that good enough? And those, unfortunately for them, in terms of asking me, those are legal questions in terms of the validity of the process, right? But that's how people are thinking. They're thinking in their ways. They're thinking through the process, and they're thinking, how can I be creative? And my only caution is just don't, obviously you don't want to do short you don't want to do shortcuts where you may open yourself up to malpractice, for example, or other factors that are not necessarily professional responsibility factors. So when people are talking to each other, they're getting a lot of good advice from each other. And if you're gathering advice and you're getting it and you think, well, I kind of wonder if this is going to work and this is good, this is going to fly for my PR responsibilities, give us a call and, we can talk you through the ethics part of it, whether or not that's going to raise any ethics issues.
I will say, go ahead, Mike.
I was just going to say, these are common questions in the communities. The solo small group, especially, pretty good about addressing ethics concerns. I'm wondering if it's worth talking about making that request for an opinion, or is that old hat for most folks? I often see in the communities say, hey, you know what? Here's my feeling, but maybe for this one, you want to submit a request. Are there some guidelines about how that process happens?
You mean with our office?
Yes.
Yeah, I don't know how, that we often do advisory opinions written, like a general, like how the IRS does like a private letter ruling, that kind of thing.
Right.
We don't do that. I mean, our advisory opinions are for that person, for those specific fact scenarios. We do issue opinions that come up that oftentimes when the bar association issues an opinion, we look at it to see whether we want to adopt it so that we can have our own opinion, so that people know how things are going to be applied. I don't know in terms of like a group having one question for us to opine upon. So I can't really comment
not
on
even,
whether.
yeah, not even just a group, but an individual. I mean, there are times when, the community is a great resource. Other times, it's maybe better to call your office.
Yep, absolutely. So if you do, that's kind of what would make sense is oftentimes, you would get the community to tell you what they do, right? And then you wonder, I wonder if this is okay. And these calls happen all the time. And then you call our office and say, hey, this is what I'm thinking. I've kind of asked around. I was told this and this. Are there any rules that I need to really consider? Is this okay under this rule or that rule? And we would be able to talk to you about that for you. The AO is limited to your conduct, so we can't talk about your colleague, whether they did it right, or opposing counsel, whether they messed up. And it's for future conduct. So, it can't be like, I did all these things, am I in trouble? type of questions, because it's done. You did it already. It's for future conduct and it's for yours. But we do get people who have done the talking around in the community, have come up with what they think was a good solution based on that. And they just want to have that one last step where they call our office and say, what am I missing? And if you're missing conflicts, for example, or whatever it is that we deal with on a daily basis, we'll let you know. Oftentimes it's not going to be necessarily a rule violation. It's going to be, that's just kind of creative way of trying to solve a problem. And we don't see a problem. So we do that. We do have those conversations with individuals.
And Mike, I'll just say, I had gotten that advisory number, and I think I put that on speed dial when we started our law firm. And I suspect it is still on speed dial on my phone. I just have it programmed in now. That's the only difference. But to switch it up a little bit, as far as releasing an opinion, I will say that the Lprb, the Lawyers Professional Responsibility Board, who the office works with, looked into actually issuing an opinion in regards to what's going on with COVID and some FAQs. In the process to actually releasing and signing off on an opinion can be a very long and tedious process, because of course rulemaking and advising in that fashion is not a fast process. And I think that's one of the reasons that we actually want to support the office's FAQs, and that's the direction I think the Lprb would like to see this go, is to see those FAQs, because things are changing rapidly and it's going to be much easier to change the FAQs and to get that information out. So we're very much in support of those FAQs when they come out. We're looking forward to it. The other thing that I just want to twist that into a plug, of course, with the Lprb, Lawyers Professional Responsibility Board, that is a board that is composed of both attorneys and non-attorneys. And our job is to sit in there and take a look at everything that's going on, to look at those opinions and whether there should be opinions, to look at the rules, to decide whether or not we should take a position on different rules, different requirements, different committees, similar to what we talked about at the beginning of our meeting here. And the Lprb also serves in a quasi-judicial fashion, where we're looking at appeals from either complaints, or we're looking at appeals from admonitions, decisions not to investigate, or those reinstatement hearings where we're presiding over those hearings. The Lprb is an important organization that I think anybody that's interested in these ethical rules and considerations should consider joining. I will say, in order to join, one of the things that is often looked at as a stepping stone to joining the Lprb is service through the district ethics committees. So if you find that there's openings on your local district ethics committee, or you want to find out more about what's going on, I will also say that joining the district ethics committee is a great way to get answers to a lot of these ethics questions that you just wouldn't think about. Issues in regards to things that go on with family law, or personal injury or criminal law that you just wouldn't be exposed to otherwise. It's a great way to get that additional information. That entire plug is also to say, right now, the Hennepin County District Ethics Committee has openings. I posted a link earlier in the chat here. I would encourage people to sign up. It is an excellent experience. It is not too time consuming. I'm more than happy to talk to anybody offline about that. But I would encourage people to get involved in this process. You find out a lot. You understand a lot about the ethics rules. It's not a significant, well, the District Ethics Committee is not a significant time commitment. The LPRB amps it up a little bit, but so that's my plug on the background.
Excellent. I'm going to make a call for last questions. We're at the top of the hour. Thanks everyone for joining us. Thanks, Bing, for your conversation. It's really insightful, really great.
Very much appreciated.
Suzanne is asking, where do they post the district committee openings? That one might be for Landon.
So for the district committee, district ethics committees, where we're finding that is under the rules, every district bar association is responsible for putting those together. That's one of the things and one of the considerations there is if you're not part of the bar association where you live or work or interested in getting involved, it can be hard to find out about that. But I will repost the 4th opening. I know the 2nd, Ramsey County, of course, also puts that up from time to time in their newsletters. Just pay attention to those. But if you're in Washington County or Anoka County or Dakota or Lake of the Woods, then the district there should have that information. They're responsible for filling those. They're responsible for ensuring that at least 20% of the investigators are non-attorneys as well. So if you have people that are not attorneys but interested in this work, that's a good way to go. I hope that answered the question. Feel free to follow up with me if it didn't.
Very thoroughly, thank you. The event code, I'll paste into chat again so people can see it for Naomi and for our online, or I'm sorry, for our phone-in callers. I'll recite it here. It's 315-091. That's 315-091. Thanks again, everybody, for attending. Next week, we're going to be talking about the recent Supreme Court case, McGirt versus Oklahoma, written by Gorsuch, I think, with Colette here. She authored, Mitchell Hamlin professor, authored an amicus brief that was cited in the opinion. So very excited to talk with Professor Colette Rutel next week about her experience writing that brief and what it's like to be cited by the Supreme Court. And of course, the case itself, we'll dive into that as well. So join us next week on the Thursday, same time, same place. And again, thanks everyone for joining us. Have a great rest of your week.